Okay. Good morning. So I have Ramona Lampley here. She's a academic professor who studies a lot of really interesting issues in civil litigation involving human rights and forced labor issues. Thanks very much for coming on today.
Hey, thanks, Patrick. I'm delighted to be here and I appreciate you asking me to be a part of this show.
Yeah, yeah. So yeah, you do really great work. We came across each other a few years ago, doing the model contract clause project with the American Bar Association. I've just been really fascinated by the research papers you've been putting out, and you've really been distilling what's a complicated area for a lot of us. So thank you for that. Um, before we start talking about maybe you could just give us a very brief introduction of the research you're doing, but then I'd like to go backwards and talk a little bit about how you got here in your own biography. But first, you could tell us a bit about your work.
Terrific. So the research that I track is basically domestic United States litigation brought by either victims of forced labor in the supply chain or by consumers who purchase products that they later find out involved forced labor or child labor in the supply chain. I've been tracking domestic litigation now since about 2017, and I've got a new article coming out in Pepperdine that looks at some of the new cases arising under the recently amended Trafficking Victims Protection Act on how courts have dealt with those cases and pointing out some disagreements of interpretation of that law that I have with recent judicial opinions.
And I'm looking forward to discussing these disagreements in interpretation in more detail. But first, maybe you could tell us a little bit about yourself and your background. We mentioned offline that before your career in academia, you were a civil litigator.
That's right. So I started off my career, I actually clerked as a judicial law clerk for the 10th Circuit Court of Appeals. I clerked for Harris L. Hartz in the 10th Circuit. And then I joined a wonderful litigation boutique in Denver, Colorado. Part of what I did there was class action defense and other types of civil litigation. It was one of my dreams to become a law professor. So that opportunity opened up for me, and I joined the faculty here at St. Mary's School of Law in 2012. Right now, I serve St. Mary's School of Law as Associate Dean for Research and Faculty Development. I also teach uniform commercial code courses, sales, secure transactions. I still teach civil procedure given my background in litigation, and I recently started teaching constitutional law. Now, how did I get involved in international supply chain? Well, I used to be chair of the American Bar Association subcommittee on sales. That's a natural link to my teaching area. And around 2017, 2018, Professor David Snyder, who is a professor at American University College of Law, started a working group to prevent humanitarian abuses in the international supply chain. And I thought, well, this sounds pretty interesting. Let me go see what this working group is all about. And they were really leading a cutting edge project where they perceived that forced labor in the international supply chain was a problem. There had been recent news stories about some very tragic events, and they wanted to work with private businesses on what we could do from an international contracts perspective to help businesses protect against forced labor in the supply chain. So the whole goal of the project was to write these model contract clauses, and it was very successful. David and Susan's work has been incredibly impactful. You probably know they have a book out on it now, published by the ABA, Contracts for Responsible and Sustainable Supply Chains. But I got involved in that project. And part of my role in that project was looking at corporate liability here in US courts for some of this forced labor in the supply chain. What I found out was that there was basically none. I mean, there had been lawsuits filed, but everything hinged on the level of control that, say, a domestic company might exert or not exert over a third party, fourth party supplier. And so reading that litigation, there was a real disincentive for US companies to try to exert control because counterintuitively, the more control a company might exert, then they were potentially opening the door to liability under case law from 6 or 7 years ago. So I was involved in writing the model contract clauses, and especially with writing some disclaimers to help protect American companies that might want to adopt these model contract clauses. But because I had
Ramona, I often, you probably wrote the footnote. There's a couple of footnotes in the model contract clauses which speak directly to this point, and those are some of the footnotes that in my work in helping companies implement the clauses, I direct them to those footnotes and I say, this is why you need to read the footnotes. Most people think lawyers are just nerds who love the small print, but actually they're really, really useful to deal with that point, particularly regarding control and exertion of control.
That's right. That's
and
right.
I wanted to say too, you talk about a few years ago, because we are in a different world with respect to new laws that are enacted, the TVPRA, the UFLPA. There's a lot more back, in 2015, 2016, a lot of the argument for doing things like incorporating the model contract clauses was due to reputation risk and a bit of litigation risk. And then to your point was that it was less of an important factor back 5-10 years ago because there was less of a litigation risk. Now we're in a situation where there is more regulatory risk. There is potentially litigation risk, which is what we'll talk about now. But I didn't mean to cut you off. I just wanted to add a little bit of that context.
You didn't cut me off at all. And it has been an ongoing, interesting debate and an interesting issue, really, about moving forward. Is it better for there to be private action through ESG work with companies taking this initiative on their own, perhaps to satisfy consumers, market reputation, as you suggested, or whether there should be more of a strong arm approach from public regulation? And I think we've seen more of that develop, especially in other countries, but we also have seen more here. And that's one of the positions I took in one of my earlier papers, was that it was 2019, Mitigating Risk, Eradicating Slavery. The discussion of the case law in 2019 was, yes, there has been very little corporate liability to date, but on the horizon are the recently amended Trafficking Victims Protection Act, which has a private right of action by any victim of forced labor. It also has a provision that Congress added in 2008, stating that it intends the Trafficking Victim Protection Act to apply extraterritorially. That means outside the United States, because that was a concern. And it allows victims to bring an action for money damages against whoever knowingly benefits financially or by receiving anything of value from participation in a venture which has engaged in providing forced labor, knowing or in reckless disregard of the fact that they have engaged in forced labor. That provision was actually amended again in 2022 to make it even broader, whoever attempts to knowingly benefit. So at the time these cases were coming about, there was a real strong thought, and I continue to have that thought, that the Trafficking Victims Protection Act was passed by Congress with the intent of opening up potential liability for money damages against U.S. companies who knowingly participate in a venture that has engaged in forced labor or forced child labor.
Hmm. That was a really great summary of the real key pieces of the TVPR. Do you go TVPRA or TVPA or?
I do call it the TVPRA because there's a Torture Victims Protection Act that that is TVPA, and it oftentimes gets confused with the Trafficking Victims Protection Act. So I've adopted TVPRA, and I think that's kind of consistent with what we see in some of the amicus briefs.
Yeah, thanks. So I think two of the key features, and so obviously the extraterritorial application is important. But I think the two key points are the knowingly benefits and then participates in a venture. Those are probably the two main areas where there's contention.
Yep, I think that's right. What does it mean to knowingly benefit and to participate in a venture? And these have been terms that the courts have been struggling with and construing them in some ways quite narrowly. I do think it is important that in 2022, in direct reaction to one of the Court of Appeals cases interpreting the TVPRA, Congress acted very quickly and amended this provision that we're talking about to include those who attempt to benefit financially.
And that was in direct reaction to case laws cases that came out that said there's disagreements as to whether or not a company actually benefited from violation of the statute of incidents of forced labor.
That's right. And it's a complicated case. It's a lengthy opinion coming out of the Ninth Circuit. The case we're talking about is Rotha versus Fontana. But part of that case involved a defendant who the goods were stopped by Custom and Border Patrol. So they never actually sold them to the retailer in the United States. And the court said, well, there wouldn't have been any benefit because it didn't go through. And that's when we have an even broadening of the language. And I'm not suggesting that they would have been liable otherwise, but we see a direct reaction from Congress broadening the definition for liability there. And what's really interesting, Patrick, as you and I have been talking about, is that because of this amendment in 2022, the plaintiffs have moved to reopen that case. And there's been amicus briefs submitted, some even by members of Congress, arguing that the intent, really laying out the legislative intent of the TVPRA, and it is to hold companies liable who knowingly engage in a business venture that involves forced labor.
Yeah, and we'll take that step by step. But effectively, the case was dismissed, then Congress acted.
Essentially the Ninth Circuit affirmed the grant of summary judgment. So yeah. In earlier writings, I've made the point that the fact that the case survived the motion to dismiss at the district court level was actually very important. It meant that this is an avenue for victim-based relief. It is an avenue for victim-based relief, even if some of the elements have been construed in a narrow way. District court granted summary judgment and the Ninth Circuit affirmed.
Ninth Circuit affirmed on this basis. Then Congress specifically amended it, or what was it? It was an interpretive revision.
So it is called a technical revision. Hang on, I'm going to get the name of it exactly right. A technical and clarifying amendment to this provision. And why that is important is because for a motion to reopen, if it's a technical and clarifying amendment, then that is more persuasive for a motion to reopen as opposed to a substantive amendment, because it means it should have applied retroactively.
Exactly. Congress is saying this was the statute that you should have been interpreting when you made the summary judgment motion. This is what you should have, what the summary judgment should have been based on, not what you did. Therefore, you should reopen the case.
That is what the clear label of this amendment, signed into law in 2022 as a technical and clarifying amendment, means directly that that's what the statute meant even prior to the amendment. Congress is just reacting to make absolutely clear what it should have meant at the time summary judgment was affirmed.
It's interesting because you're a constitutional law scholar as well. You're a constitutional law professor, so you can actually teach your students this dialogue between the legislature and the judiciary and how this interplays with each other.
Absolutely. It's such an interesting separation of power, reaction to decision, and then commenting on the decision, with Congress really trying to signal to the courts that no, when we wrote the Trafficking Victims Protection Act, which I'll be honest, does have some ambiguous parts to it, but this is what we meant. And the the quickness in time that Congress acted after this decision came out, that closeness and proximity in time also strongly suggests it was a direct reaction to that decision.
And now we're at the point where it's not just implication, and it's not just the attorneys for the plaintiffs who are arguing this. A few congressmen actually filed an amicus brief to the Ninth Circuit.
Yeah, that is just really, I mean, in my academic world, that is just really cool and interesting. It's interesting because we have these 6 members of Congress who were directly involved with the Trafficking Victims Protection Act, with writing the legislation, with writing the amendment, and they are writing this brief telling us exactly what they intended by the original legislation and all of the amendments. I mean, if you're a law professor, it really doesn't get that much better than that when you have Congress writing a brief saying, here's what we meant. Now, it's 6 members,
yeah.
6 members of Congress is really important there.
Yeah, it's almost like they're acting as witnesses, filing a declaration on behalf. Almost. Yeah.
Now, Congress was fairly explicit when they passed the TVPRA. There are findings of fact and statements of purpose in the actual legislation that does a really nice job of telling us what congressional intent was. But this brief just adds another layer on it for any court willing to take a look at what the stated legislative history is.
So now that was one of the key things I read in your article that I wanted to have you on to talk about. We got to it relatively quickly. Maybe we should take a couple steps back and maybe talk about the Alien Tort Statute, kind of the status of the law and litigation in the early 2000s. You know, when I was in law school, I was learning about this. So I was in law school around 2008, and I was learning about using the Alien Tort Statute in this kind of interesting. So maybe you could talk about, that was kind of the first iteration of rights of action for human rights abuses. And then
right. So the Alien Tort Statute is a very old law that opens the door for liability for a tort only. And it is
Wasn't it a law passed so that they could prosecute Barbary pirates off the coast of North Africa committing piracy against U.S. shipping?
Right. The legislative history is very opaque, and it hadn't been used for a long time. But then we start seeing the ATS used in all kinds of ways by foreign victims, and it raises all kinds of jurisdictional issues, because usually we're the basis of the claim is something that happened outside the United States.
Yeah, it's a tort. It's a tort that happens outside the U.S. rather than inside the U.S. So it's a tort that happens extraterritorially.
And you can see why, absent any other more direct legislation, opportunities for victims to bring suit against United States companies based on alleged torts or labor abuses that happened in their own home country, and that is what we're talking about here. Say labor abuses that happen in the Ivory Coast or in Thailand. So outside the United States, the Alien Tort Statute looked like a useful statute by which to grant the United States courts jurisdiction. But there's a robust body of case law dealing with the ATS in multiple different contexts that really restricts courts' abilities to open up a new cause of action under it. But more importantly, that applies something called the principle against extraterritoriality. And this principle that the Supreme Court has set down, the principle against extraterritoriality, says essentially that we will not construe American law to apply to foreign acts on foreign soil unless Congress tells us explicitly that it does. And so that's one reason why this was a seminal case. Doe versus Nestle, it went up to the Supreme Court. I believe it was decided in 2021 or 2022. The Supreme Court says the ATS does not apply extraterritorially in this instance.
And you'd
So
been writing for 5, 10 years that courts had been leaning towards this. The lower courts have been leaning towards this. The Supreme Court had been giving indications of this. The 2020, the Doe case was kind of the death knell for the idea of bringing an alien tort statutes case.
it would
But
have been
but it was, it's been difficult throughout.
right. It would have been extraordinarily surprising to me for the Supreme Court to have gone any other way. They were staying true to their case law and the principle against extraterritorial reach, which is a generally applicable principle, but as applied to ATS there, unless Congress tells us we do not construe American statutes to apply to foreign acts on foreign soil.
Which is also important. So you see the ATS litigation starting to rise at the turn of the century and coming up, and then you see the backlash against its being applied extraterritorially, which is why you see something like the TVPRA coming into force and explicitly saying we are going to apply this extraterritorial. Or am I missing anything in between? Or
no, I mean, I think that really captures the historical timeline, because a number of these cases dismissing claims under the ATS would look to the TVPRA and say something like, we recognize that Congress has enacted an extraterritorial provision under the TVPRA, but these plaintiffs' claims predate that. So really suggesting and signaling that for future cases following the 2008 amendment with the extraterritorial provision to the TVPRA, that's going to be the avenue for relief.
Mm-hmm. And so that was kind of in the mid 2010s, 2012. You're starting to see courts and plaintiffs litigators focus on the TVPRA instead of the ATS. But
That's right.
still, there are difficulties in actually pursuing cases under the TVPRA. And maybe we could just talk a little bit about the type of the quintessential cases that you're seeing applying the TVPRA. So you have the Thai fishermen cases, you have the child slavery cases in Western Africa. I think those are kind of the two, and then the cobalt cases in the country. But you tell me.
No, that's exactly what some of the leading cases are. There's also been a more recent case filed on disposable gloves. But let's take, we'll just take one of the cases, Doe versus Apple, as an example. So the allegations are brought by plaintiffs who are involved in mining cobalt in foreign countries, brought against United States-based companies that use cobalt in electronic equipment. And according to the allegations, mining cobalt is actually fairly dangerous, especially for children. There's mining shaft collapses. The plaintiffs recount numerous examples of death or serious bodily injury to themselves or their family member against these defendants. And they brought the action for money damages under the Trafficking Victims Protection Act, saying that the defendants had a knowing benefit by engaging in a venture when they knew forced labor from mining cobalt was involved. Now, again, that's the allegations, that's the complaint. And I'm raising this because this is one of the most important cases that we have right now dealing with the Trafficking Victims Protection Act. Is on appeal to the DC Circuit, but the federal district court in that case really eviscerated the Trafficking Victims Protection Act on a number of grounds. In my view, one of the most difficult grounds is the district court said that the plaintiffs lacked standing to bring their claims because they could not show the United States-based companies caused their injuries, that there's an indirect supply chain, that the smaller artisanal miners, if anyone, is responsible for their injuries, and that the plaintiffs could not show what essentially, to me, reads like a requirement of but-for causation, that they didn't have standing to bring those claims. Now, that's also linked to the finding that the companies didn't participate in a venture because the court said that the plaintiffs hadn't plausibly alleged knowing benefit or participation in a venture. But the most problematic hurdle there is judicial standing.
Hmm.
Yeah.
And just to be clear, like the way the mineral supply chain works is that there are several different intermediaries. There's usually a mine. Oftentimes there's mines that are owned by large kind of Asian refineries, but oftentimes there's also smaller artisanal mines, which are much less regulated, much more it's much more prevalent to have issues related to forced labor, child labor, things like that. So the small mines or the medium-sized mines sell it to the middlemen in, let's say, let's say the Congo. Those middlemen then sell it on to the refineries who are going to export the goods, let's say, to China. They export the goods they export all of these different minerals to China. And it gets smelted in the refineries in China. And then it's incredibly difficult once the smelting takes place to determine and track which pieces of cobalt come from, say, traffic mines versus which pieces of cobalt come from bona fide legitimate mines. Which is dissimilar to something like, say, diamonds, where it's oftentimes there's no smelting, so you can kind of track and trace from the ground all the way through, although there's difficulties with respect to that and plenty of illegitimate conduct there. But and then from after the smelters, it then goes into the processing, and then eventually these minerals end up into your phones. Right? But is that about right? Is that about what's being alleged in the complaints?
From what I understand of the allegations, that is one of the difficulties, is that there is so many different sources from which the cobalt is mined, and then it is all intermingled. But when we talk about the standing issue, the court really focused on the fact that the plaintiffs had not alleged that these defendants directly caused their injuries. And that's going to be a problem in any importation of goods case.
Okay. Yeah.
Because we're talking about foreign workers working for different employers who were somewhere down the supply chain, regardless of the level of knowledge or disregard that the U.S. company might have.
Well, which is why we get to the key portion, which is attempting to benefit from, right?
Mm-hmm. Yeah.
Okay.
That's right. Well, so the attempting to benefit portion, one reason that is there is because let's say that there is direct evidence of forced labor in the supply chain, and that the goods are seized, they're blocked, or maybe the United States-based importer finds out and says, we're not going to purchase them, or we're going to return them. So then is there a benefit if you don't profit from it, if you don't make money from it? Well, that's why the attempt to benefit provision was put in, so that you can't just say, oh, I found out and I'm not going to pay for it, but I did know all of these other years, that's not an easy escape route. Because that's sort of what was alleged in Rotha, is that the goods were stopped at the border and they weren't ever actually sold to the US based buyer. And so the court held, well, you didn't benefit from it because it stopped. And I think that there's a lot of different ways to look at benefit, but that's when Congress said attempt to benefit. Can it be used in these other cases? I mean, absolutely. But if we believe the allegations as is appropriate on a motion to dismiss, then the plaintiffs have a good case for at least getting to discovery on knowing benefit.
Exactly. On whether they knew.
Right. Yeah. I mean, many of these statistics are public information. The U.S. Department of Labor publishes, about the U.S. Department of Labor publishes a report on goods that are manufactured and sourced with known problems of forced labor in the supply chain and their countries of origin. So that's a public report. The industries follow it. It's information that any consumer can get. But even getting to that stage of the discovery to be able to prove a knowing benefit would be important from a victim's rights point of view.
Well, and what'll be really interesting is the interplay with foreign law and the U.S. law, because now we're getting in the EU context these due diligence legislation. So Germany, France, potentially the EU wide are going to be requiring companies that are subject to their laws to conduct human rights due diligence through their supply chains and understand exactly the circumstances of their supply chain. So if you have a company that's subject to both jurisdictions, and many of these multinationals are, you'll have situations where a company is forced to discover these issues. So it'll be very difficult for them to argue in 5 years that they didn't have an understanding of the circumstances of production because they're obligated to.
And I have not focused on the international scene and what other countries are doing as much as what as my focus has been in the United States. But I think it is very interesting how that dichotomy has arisen, how other countries are really acting with the strong arm of legislation to require companies to exercise due diligence, where the United States has not come out, from a global perspective and acted that strongly, but they have acted through the Trafficking Victims Protection Act. I mean, one way to cause change in this country is to open the door for money damages. So that's what I believe Congress was doing here.
Well, Congress is doing that there. And then you also see the more robust enforcement of Section 307 of the Tariff Act, which prohibits products produced using forced labor from entering the country. So you have, and this is something that started, really with the Trump administration, where they started more robust enforcement of Section 307. The Customs and Border Protection Department started issuing more and more withhold release orders. And I think that's what you're talking about in the context of the gloves cases.
Right. That's right. Yeah. One of the amicus briefs to the case pending or on appeal to the Ninth Circuit really draws down some incredibly interesting statistics on the amount of withhold release orders that have come up in recent years. And I know that you've done a lot of work in this area on researching it as well. So I think that the national awareness of the issue has increased so much since those early 2000s.
Yeah, what we often say is that in the U.S. we have almost a strict liability regime where the U.S. they're not going to dictate how you go about investigating your supply chain, but if you have problems of forced labor, child labor in your supply chain, there are these mechanisms that you could face punishment either through civil litigation, through having a WRO, through other issues where you might have your products detained. But then in the EU context, is more of a process-based approach where currently they're saying we're going to specify how you conduct due diligence in order to determine whether or not there are issues. And then they're hoping to also enact legislation which prohibits products produced using forced labor, but still right now it's more of a process-based approach. And all of this is to get back to the points that we were talking about at the very beginning, as to why companies are at a place now that they weren't in 20 years ago, why they need to do things like incorporate these model contract clauses, and why they need to be cognizant of the circumstances of production. So, yeah.
Well, there's one more important piece of that analysis that we haven't fully talked about, and that's consumer class action based litigation in the United States. And back in 2017,
here, let's just do a quick overview. So we've got the regulators. So we've got Customs and Border Protection that could issue withhold release orders, detain your shipments, things like that. We've got the TVPRA, which gives victims, affected stakeholders, a private right of action. And then now we have consumers who purchase the product.
That's right. Now, in the earlier paper that I wrote looking at domestic litigation, mitigating risk or eradicating slavery, I thought the consumer class action cases were really a big deal. Several cases were filed in 2017, 2018 in California And then in the First Circuit, alleging for the various products, you manufacturer didn't disclose that this product has an ingredient that was sourced with, for example, forced child labor. I wouldn't have bought the product if I had known. Therefore, you've engaged in a consumer misrepresentation to me. There was a whole slew of cases filed, and they all met with a motion to dismiss in the under various state consumer protection laws. For example, California CLRA, basically courts holding that the manufacturer didn't have a duty to disclose anything in the supply chain as long as it didn't create a risk of personal safety to the consumer, and the manufacturer had not created a misrepresentation. So that was consistent wall of dismissal, both from California filed cases, and even the First Circuit had a similar opinion based on Massachusetts consumer protection law. Now, my thought back in 2019 was just the filing of the class action and that it hits headlines, and there's now more increased consumer awareness that these products are potentially sourced with forced labor, that creates a market risk, which really informs what the company should be doing in their contracts privately, right? You want to take care of consumer awareness, make the consumer happy. But fast forward to 2022, and we have a new class action pending in California under the UCL and the California Legal Remedies Act, where the plaintiff has survived a motion to dismiss. It was originally Walker versus Nestle. Now it's Falcone versus Nestle, alleging that the packaging of the products that she bought created in her mind a misunderstanding that cocoa, those products were sourced from supply lines that didn't use forced labor. And the court has allowed that claim to go forward past the motion to dismiss, which is different from those earlier cases. And the parties are now going to be in the very early stages of setting a scheduling order, moving forward to discovery, both on the merits and on class certification.
Yeah, and just for the uninitiated, there are several reports of incidences of child labor and forced labor in the cocoa chocolate supply chain, particularly out of Western Africa.
That's right. The Department of Labor report has that. Also, many of the websites for our domestic chocolate companies, when you go to their website, you might have to click around a little bit, but you will find reports where, from a marketing perspective, they acknowledge that this is a problem in the industry, but then they will make representations about what they are doing as a company to try to eradicate it. But the presence of child labor in the cocoa supply chain has been something that the United States government has reported for many years, even decades.
And so it's incumbent upon the companies to implement responsible supply chain processes so that they can avoid some of those instances. And what we argue at the working group is one of those responsible frameworks that you can add is contractual clauses, which allow for human rights due diligence, remediation, and all of these kind of best practices. If you put them in contract, it will facilitate your conducting the reviews.
That really is one of the beautiful things about the contract. And from a 50,000-foot point of view, I teach contracts to entering law students, and we don't think about it that much, but under American law, you are paying and the contract is fulfilled when you get the product that was specified. Up until the evolution of the MCCs and supplier codes of contract, how the product was made was really not part of the contract. So if you contract, I'm going to use Professor David Snyder's example here that he uses many times. If a company contracts with a foreign supplier to buy soccer balls, and they get soccer balls, and that contract has been fulfilled, no matter who made them and under what conditions. So you have to make worker conditions
Yeah. What they often talk about, they talk about product defects and process defects. So
Right.
product defects can allow for contractual remedies, and we want to put process defects on the same plane as product defects.
Absolutely. Very well said.
Yeah. And well, I didn't say it either. That was David. That was David's line. The key point in ensuring that process defects will be put on that level is ensuring that products that are tainted by these process defects can't kind of keep going in the supply chain, that they have to be stamped out, and that companies have the belief that they have to ensure that those products don't keep going in the supply chain.
It gives the company grounds for declaring breach and to reject the goods. So you need, in order to properly reject or revoke, there has to be a breach. So it makes it part of the contract that when you supply goods that are sourced with forced labor, as the company defines it, or child labor as the company defines it, that there is a breach. And it puts the definition of all those things in the hands of the buyer, the company.
Yeah, the buyer, especially because if you're, say, a chocolate supplier, you certainly have a specific issue with respect to child labor. Whereas, if you're a buyer of a product where that's not as prevalent in your society, you might have issues related to sustainability or toxic materials. And so your code of conduct is going to focus on those issues. So the model contract clauses leave it up to the buyer. Okay. So I think
they're not just limited to reject, I'm not going to take your goods, but one thing they've been working on really extensively is additional remediation. All right. So now we have a breach. We have traditional remedies, such as rejection, revocation, non-payment, but now working on taking things to the next level for the benefit of the workers, but also the consuming market of remediation. So how do we fix this going forward?
Yeah. How do we address this problem rather than just rejecting the goods, suing for damages, finding a new supplier, and allowing that supplier to continue with its type of conduct, implementing remediative measures that address the root causes of the issues. Okay. I'm wondering, is there anything we haven't covered? So we talked about we talked about kind of the different reasons why companies need to be cognizant of how their business practices and their supply chains might damage them. And we talked about ways, particularly the model contract clauses, that they can implement responsible practices. We've gotten into the weeds a bit more than I thought about the cases, but I think this is really fascinating, and the work you've been doing is really, really great. Particularly with respect to the RADA, the Ninth Circuit cases. We talked about the DC Circuit cases, the Doe cases. Is there anything else that you wanted that you think about?
We have covered a lot of ground, and I'm really grateful that you're doing this podcast and for the work that you present as part of the working group. It certainly keeps me informed. But I think what I would close out with is, even in a short amount of time, the time that I got involved in the working group and started looking at cases, we've really seen a significant shift in consumer awareness about sustainability and about how products are made. And so I would just continue to keep an eye on things like the consumer class action and how that drives change, and also federal legislation. What happens is the courts continue to grapple with the Trafficking Victims Protection Act. But I think that you kind of hit the nail on the head when you said what other countries are doing are going to have external effects on products that come into the United States. Consumer awareness is such a big piece of this when we think about how impressive the marketing power of our companies has on the ability to create labor changes in other countries. So when consumers start demanding it, either through purchasing products that are really and truly sourced with fair trade, fair labor practices, or by successfully alleging and moving forward with consumer protection class actions, then I think we'll have more attention from companies.
Yeah, yeah. I think the stakeholder litigation, it's relatively discreet and it's relatively difficult and it's incredibly factually difficult. Whereas the consumer, part of the reason why the problem is so broad is because these products are purchased by everyone. We're gonna have Halloween where
No, I
if
know.
people as a parent, if people understood that all of this joy is being created by children on the other side of the world who are in these incredibly harsh conditions, it would give you a sense of pause.
Well, I think that that's part of the work you and I are doing. I think that there is some sense of lack of awareness in the consuming public that the government wouldn't allow goods to be brought in if they were sourced in a way that was really this bad, that the problem was really this pervasive. And then when you start pointing out, well, the Department of Labor reports that shows the statistics in the most problematic goods, consumers do want to pay attention. They do want to do the right thing as long as their pocketbook will allow them to do that. I think it's really about building awareness. And when it comes to consumer protection statutes, I mean, just look how far we've come in a couple of decades about what the consumer expects to know. So I think we'll see more dynamic change in that area.
And I think, and to David and Susan, yours credit, it's not only explaining to companies that this is an issue they need to care about, it's also giving them the tools to help them reduce these issues, because I obviously they're not ghouls at these companies. They want to do the right thing. They just, part of it is they need the tools to do so, and things like the contract clauses are effective tools.
Right. That's why I think it was such a visionary project for David and Susan to initiate, was recognizing that there was a gap here in traditional contract law, and that we as academics and private practitioners could come together through the ABA and help fill in that gap to give companies a tool.
Well, thank you so much for coming on, Ramona. And really, thank you for the work you're doing, because we all don't have the time to really get into the weeds on all of these issues. And it's so helpful to be able to have your synopses, on every couple of years.
Oh, I appreciate it. And thank you for the work you're doing as well.
Cheers.
You have a great day. Thank you.